Yes, Your Honor. My apologies. I lost track of time.
No worries. I was just mentioning I will not have my camera on today. So if we could just go ahead and get Mr. White, or are you and your client okay with that?
Yes, ma'am.
Okay.
Annex or downtown facility, do you have Mr. Zachary White?
He's on his way.
Thank you.
And then while we're waiting for that, this is Judge Alyssa Perez presiding over the 210th District Court criminal docket for June 28, 2022. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Again, as I was mentioning to the parties, I am operating remotely and don't have full access to my camera. And so I'll just ask anyone who wants to reschedule for whatever reason, that or any other, just let us know before we get started with your case. Mr. White, this is Judge Perez. Is that you?
Yes.
Mr. White, I'm going to be asking you some questions. We're set for a plea today. Let me go ahead and get the case called. However, with the audio, sometimes there can be some interruptions. So please let me know if at any point you can't hear me or the attorneys, okay?
Okay.
All right, go ahead, Mr. Medical.
In cause number 2021-0D02646, State of Texas versus Zachary Ethan White. Announcement of counsel, please.
What came from the state of Texas?
Jeep Darnell for Zachary White. Mr. White is... That doesn't look like Mr. White to me.
Sir, would you state your name?
Zachary White.
Oh, there we go. Okay. Sorry about that. And my client is appearing from the annex by way of video conference. Please don't tell my wife I said that about her.
Okay, don't confuse me. I'm a little under the weather, Mr. Darnell. Mr. White, do you recognize your attorney?
Yes, ma'am.
Okay, beautiful. We're scheduled for a plea today. I'm going to be asking you some questions, which means I need to swear you in. Would you raise your right hand, please? Do you swear or affirm that any testimony you provide will be the truth and the whole truth, sir?
Yes, ma'am.
Would you state your name and date of birth for the record, and you can put your hand down.
Zachary White, 7/9/2000.
Mr. White, as I mentioned, we are scheduled for a plea today. I have plea papers indicating your intention to plead guilty today. First, I'm going to ask you about documents. State's Exhibit number 1 are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. White, have you reviewed State's Exhibit number 1 with your attorney and signed that document?
Yes, ma'am.
Did you understand everything contained in that document?
Yes, ma'am.
Mr. Darnell, have you had more than 10 days to prepare a defense in this case?
I have, Your Honor.
And did you explain the plea papers to your client?
Yes, ma'am, I have.
Do you believe he's understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do, Your Honor.
Mr. White, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Darnell, do you have any reason to believe your client is not presently competent to enter his plea?
No, ma'am.
Mr. White, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
Yes, ma'am.
Any condition diagnosed or any other undiagnosed condition affecting your ability to understand what we're doing today?
No, ma'am.
Have you been able to effectively communicate with your attorney throughout the entirety of your case, including in preparation for today's plea?
Yes, ma'am.
So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Indiana, Indianapolis.
Okay. The charge against you in this case is a failure to comply with the registrations with a pre-registration and with a previous conviction. To that charge, sir, I believe it's a third-degree felony in this case, punishable from anywhere between 2 and 10 years confinement. To that charge, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element of the offense charged, failure to comply with sex registration beyond a reasonable doubt. Your Honor, the defendant is pleading to 2 years in TDC. And at this time, the state moves to admit Exhibit 1 as the state's plea paperwork, Exhibit 2, Article 3914 disclosure, and Exhibit 3 is the indictment.
Any objection?
No objection, Your Honor.
Without objection, states 1, 2, and 3 are admitted. Mr. Darnell, is that your understanding of the plea agreement?
Yes, ma'am, it is.
Mr. White, is that your understanding of the plea agreement?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. White, do you recall reviewing the trial court certification with your attorney and citing that document?
Yes, ma'am.
It was signed by your attorney and signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of failure to comply with sex offender duty to register with a previous conviction, and I will sentence you according to the plea agreement to 2 years confinement in the Texas Department of Criminal Justice Institutional Division. You will receive credit for any and all time that you have served. Is there anything further, Ms. King or Mr. Darnell?
Nothing further from the state, Your Honor.
Your Honor, a couple of things real quick. My client has been found indigent. I was appointed to represent him. I would ask that he be given jail credit towards his court costs in this matter.
Yes, sir. Mhm.
And then secondly, is there any way I want to confirm he should have about 13 months in custody, and I just want to confirm with the clerk that was what they were showing.
That I'm not sure. Is Miss Melendez? Is she here?
Yes, Judge, I'm here.
Okay, my docket reflects about 260, it says 262,
Correct, Judge. Yes, it's 265.
265. Does that conform with what you were thinking? Doesn't sound like it.
Your Honor, I was thinking he had been held at the jail facility in Amarillo prior to being brought here. And I don't know whether for like 30 to 45 days. That was where he was arrested on this charge.
Mhm.
There's,
mhm.
sorry, go ahead. So Mr. Donnell, so there's no warrant on it, so therefore it's not showing, reflecting on our end. There's no detainer on it.
Weird. Okay, because he was arrested on this charge in Amarillo.
If you have something, Mr. Darnell, that you can provide to the court showing the dates, and you want to make a request to the extent that, we can do that to credit it towards his time, I'm more than happy to do that.
Your Honor, I don't. That's the problem. All I have is the file, the portal file, saying that he absconded from here and was found in Amarillo, and then so on the narrative says that on October 6, 2021, at 5:45, my partner Deputy R. Rivera and I arrived at 9100 South Georgia Street, Amarillo, Texas, to pick up offenders Zachary Ethan White for booking on warrant JMAG 2109228, a pink warrant for failure to comply with sex offender duty to register, issued by the jail magistrate. So I guess the bigger question I have is what are we showing here as his arrest date on this warrant?
It would be the booking date on 10/6/21.
That's the same date. Mhm.
Okay, because on the jail record search detail on the county website, they're showing August 9th as a booking date.
And I'll just ask clerk if you can confirm that. I don't have access to Odyssey, so.
That's not what it is.
Yeah, Judge, we don't actually have that. We have just the booking date of,
Mm.
I will,
Maybe you can get something, Mr. Darnell, from Amarillo that shows the August to October dates. If you can get them to the court fairly quickly, again, I don't have a problem if he was being held
Correct.
to give him that credit.
Your Honor,
Monday.
this is Marissa. I was looking at the jailing side, and
Mhm.
what I see is that there was a hold
Uh-huh,
in Deep Smith County,
okay.
but it says it's a violation of probation.
Yeah.
And it does have a booking date, but it's for that violation of probation hold, and he currently has a parole hold.
Mm.
Yeah.
The JMAG warrant doesn't have any earlier date that I can see before October 6th of 2021.
Mm.
I'll have to find the original warrant to see when it was issued,
Mhm.
and if there's a detainer, but there's nothing reflected in the system, both on jailing or on the holds.
yeah, and I don't have access. That's what my problem, Your Honor, is I don't have access to the detainers.
Mhm. Well, Marissa, see if you can find anything. I mean, if, like I said, if we find something that conforms with that booking, again, yeah, I don't know if the dates will coincide, but whatever we have in terms of when our warrant was outstanding for him, as long as it's, in that time period or includes that time period beginning August, then I don't have a problem with giving him that credit.
Thank you, Your Honor. I appreciate that. I'll do what I can to get that. I'll keep looking. I'll look through the portal file again, but
So it's about 60 days potentially that we're looking
yes,
at.
ma'am.
Okay, all right, Mr. White, I hope you were able to hear a little bit of the discussion. Those dates are still outstanding, so we need to find out if indeed we have something to reflect that, and I don't have a problem giving you credit for it. I just don't have it in front of me.
Yes, ma'am.
Okay,
Yes, ma'am.
all righty. Anything else for today,
No, ma'am.
Mr. Darnell?
Your Honor,
Mhm.
I show right here, I found it. The warrant of arrest was issued August 9th by a JP court here.
By a JP court?
Yes, ma'am.
Hmm.
I'm sorry, by Linda Estrada, criminal law magistrate.
Or JMAC?
Yeah, and
Okay.
it shows it August 9th, 2021. It's in the file.
Okay, and then we have some kind of jailing, something showing that he was actually in custody on that date.
Yes, ma'am. If you look at the jail record search detail in El Paso County, it shows the issuing date of August 9th, 2021 to match that.
And so that's what I mean. He was actually in custody on that date.
Yes, ma'am. And that's where they're showing, if you, I mean, I'm paraphrasing a lot of police records, but essentially they had him in custody there, found him, and then an officer was sent to go pick him up on the detainer.
Okay, Marissa, we'll see what you can come up with, okay?
yes, Judge.
Thank you. Anything else?
No, Your Honor, that's it. I do need to inform my client. I did check with the parole division and his prior parole has termed and he is no longer on parole. So he does not have to worry about that.
Okay.
Alrighty.
Thank you, Your Honor. May I be
If there's-
excused?
You may. Thank you, Mr. Darnell. Thank you, Mr. White. We
Thank
will
you.
follow up on the remaining jail credit.
Thank you, Judge.
Uh-huh. Okay, who's next?
Downtown, who do you have?
Hello, I have Johnson
Okay,
Raymond.
let's do that one. It's a probation case.
Probation case on page 6, Judge.
Mhm.
Hi, Judge.
Hi. Go ahead.
In cause number 2015-0D00322, State of Texas versus Raymond Johnson. Announcement of council, please.
Roa King for the state of Texas.
And Myrna Pages for Mr. Raymond Johnson, ready, Your Honor.
And Mr. Johnson is appearing from the downtown jail. We are scheduled for a pre-revocation hearing. I did receive a case summary from probation with quite a few details. I don't know, Ms. Pages, if you possibly have some additional input, because I understand there are potential mental health concerns here. But at the end of the day, the recommendation, because he termed on April 15th, was to extend him for 1 year. Is that right, Carla?
Yes, Your Honor.
Okay, so I don't know if there were more details kind of that might be you want me to consider, Ms. Pages, but I'm on board with that. So if he's amenable to extending 1 year, we get him rescreened. I think part of the problem in previous evaluations was I guess his situation was not severe enough for him to be placed on a specialized caseload. So I don't know if there are any other concerns or needs. Do we need to do something to help him be successful? So anything that you can inform the court of would be helpful.
Yes, Judge. So I did speak with my client earlier. If the probation department can screen him for mental health, I think that will definitely be helpful to him and him being able to do what he has to do while he's on probation. I am not going to object to extending him for a year. I would be very happy with that. But if we can, how soon can he be screened, and how will he know that he's being released and all that stuff?
So is he receiving, he's been in custody for 28 days. Is he receiving any treatment in jail? Do you know?
I don't believe he is, Judge. I did not see any flags. Let me double check though.
So I don't, unless there's, Carla, do you have anything in addition to the case summary?
Your Honor, the only thing I wanted to point out is, so a year ago, we had already, I'm referring to July of 2021. Mr. Johnson did have a motion to adjudicate filed. It was dismissed. The plan was for him to be released and continue on probation. There were previously, there had been where Mr. Johnson was referred to EHN with Tacoma to see if he qualified under our caseload. But at the time, and I'm referring to June 14, 2021, probation officer's notation was that he was admitted through Tacoma, but he did not qualify to be placed in the MHI caseload through probation because of the level of care he was under. So I'm not sure where we're at right now with his level of care, if anything has changed from then. The issue was that was June, July when he was dismissed. And then come October 2021, he stopped reporting to probation until he got arrested on the KPS again, on the bench warrant, I believe on May 28, 2022.
So, Judge, so with the court, because I'm not seeing any flags for mental health in Odyssey, but I do believe that is definitely an issue. Should we come back and see if perhaps I can have my social worker meet with him and see about maybe a possible assessment in jail, see if he can qualify Now, at this point,
Ms. Garcia, did you turn on your camera for some reason? Do you have some, do you have some input here, or you just, I wasn't gonna call on you, but I saw your camera come on, so.
In
Look,
case
here's-
you needed me to follow up in jail and get him to see if he will agree to see one of our providers in jail, I could do that at this time.
okay.
I think we'll go ahead and do that, because really the crux of what I think Ms. Pineda is trying to nudge me here is that we've gone down this route before. And so I'm kind of assuming that the mental health angle is the reason why he decided to stop reporting, but maybe it's not. Maybe he just wants to blow, what is it, how long was he on? 7 years of deferred probation. I find that kind of hard to believe, but okay. I'll give them, do we have we're at a pre-revel right now. What's our next setting? Do we have a revel in 2 weeks, or do we have nothing scheduled?
Judge, there's no future hearings.
Okay, so we're gonna come back in 30 days. A reset of 30 days on the pre-revel.
Okay, Judge.
Okay, if there's information sooner than that, Ms. Pages, either between EHN, see, I see him shaking his head. I don't know. I'm gonna defer to you all, see what you can find out. 7 years, but you know, we've had some recent issues with Mr. Johnson. Maybe you'll have some more details in
No.
addition.
Excuse me,
Yeah.
ma'am. Can I speak?
I would refer you to your attorney. I mean, what do you want to tell the court, Mr. Johnson?
I've actually been working. I have a contract with a private company out of Denver, Colorado, and
So I'm gonna go ahead and stop you right there, because I don't know if you had permission to leave, because I think you were in New Mexico, you know. So let me just stop you right there.
Okay.
We're still gonna come back in 30 days. If the sole issue is that, you know, there are other responsibilities and he's well aware of his decision not to comply with his reporting on probation, that's a problem. But I don't want to jump to conclusions, Ms. Pages. So let's see if you can get some more details, see if we can fill in this picture, and I'll come back in 30 days.
Okay,
need to-
Judge, and you had mentioned Miss Garcia. I don't see her on there. I just want to make sure I have her name so that I can.
Lourdes Garcia, she's.
Lourdes, okay.
Mhm.
Lourdes Garcia. Okay, thank you so much, Judge. I appreciate it.
If you need to call Myrna with her contact info later, we can get that. All right. Is there anybody else? We're coming back in 30 days. Thank you very much. Is anybody else at downtown?
No, Your Honor, that was the only one.
Okay, thank you very much, downtown.
Your Honor.
Who's next?
Excuse?
Yes, ma'am. Thank you.
Thank you, Your Honor.
Back on page 4, Judge. Annex, may we have Aguirre, Fernando Aguirre?
Go ahead.
Because number 2022.
Let me just stop real quick. Does he need an interpreter? Does Mr. Aguirre need an interpreter?
Yes, Your Honor.
Okay, let's get an interpreter and we'll come back to Mr. Aguirre.
Yes, Judge.
Mhm. Next one.
On page 6, Judge.
Mhm.
Annex, may we have Enriquez, Benjamin Enriquez?
If anyone else will be needing the interpreter, please let Mr. Marufo know so we can take up everyone who needs an interpreter at the same time. All right. And who has Mr. Enriquez?
I do, Your Honor, for the public defender, George Driscoll. I'm covering for Brent Stevens.
Okay, all righty. All right, is that Mr. Enriquez?
Yes,
Mr.
Your
Enriquez,
Honor, that.
do you speak English?
Yes, ma'am.
All right, perfect. Let's get started.
In cause number 2022-0D02012, State of Texas versus Benjamin Enriquez, announcement of council, please.
Rolla King for the state of Texas.
George Driscoll for Mr. Brent Stevens covering, and we are here for Mr. Benjamin Rodriguez, or sorry, Enriquez, I apologize, Your Honor.
Okay, and Mr. Enriquez is appearing remotely from the jail annex. We are scheduled for a bond hearing. I understand he has another case, 2020 0D02009, but that he is already on PR bond. We just have this one case holding him. I show his bond being 150,000 cash surety. Mr. Driscoll, you may proceed.
Thank you, Your Honor. Mr. Enriquez is a 17-year-old male resident of El Paso for life. He is a U.S. citizen. He resides with his mother, Maria Munoz, here in El Paso. He also has family that resides in the home with his mother and has support for appointments and other requirements that the court would require. He has employment history with Carl's Jr. locally and has the possibility of regaining that employment if he were released. He is a single male. It's still enrolled in high school at this point at Jefferson High School and has one child on the way. So a soon-to-be father, I believe his girlfriend is due in the coming months. Mr. Enriquez has some MH-related concerns with ADHD and depression, as well as anxiety. At the time, he is not receiving medications, however, has a prescription for Concentra, which normally he has done, and our treatment options, if released, would be to refer him to Takumi for follow-up services and provide him with medications, as well as appointments so he can follow up on his mental health issues. He does have stable residence with his mother at home and no complaining witnesses concerns at the location. And we believe that he is not a flight risk. We would ask the court to consider reducing his bond.
Okay, is that everything, Mr. Driscoll?
Yes, Your Honor.
Ms. King?
Yes, Your Honor. The state respectfully opposes the bond reduction. We do have, considering his age, there is a quite bit of history. Started juvenile 2015, prohibited weapon, knuckling and unlawful carrying of a weapon. He was placed on 6 years of juvenile probation. 2016, we have a robbery. I believe I saw it declined. There's also possession, a POM in 2016. There is a criminal mischief that he was also pled true to. There's also theft of property in 2017, a misdemeanor. I believe he was adjudicated and he was placed on probation for 4 years. And Your Honor, we have been in contact. This is just some of the criminal history. We have been in contact with the complaining witness. My page is loading. I believe we spoke to his brother, and we couldn't get a hold of the complaining witness because I believe he was visiting out of the country at that time. And that was June 14. And he does also have the other case, that's the possession pending case. And therefore, Your Honor, the state respectfully opposes the bond reduction.
What's the underlying on the engaging? What's the underlying offense? So it's engaging, but doing what allegedly?
I believe it's a robbery, Your Honor.
Robbery?
That's my understanding.
Yes, Your Honor, I believe it is.
Who's the complainant? Is it a business, a person? What is it?
It is a person, Your Honor, and I believe that my client has no previous knowledge or interaction with the alleged complaining witness. I believe it was at a funeral service. I know the court doesn't want us to go too far into the facts.
And Your Honor, this did involve including the current defendant that we're with. It did include 4 other offenders as part of this case.
Had we had a previous bond hearing? It seems like it's pretty early on in the case. I don't think we've even had the.
I don't believe so, Your Honor, from Mr. Stevens's notes.
No, Your Honor.
Okay. Was there a weapon? What weapon? What's alleged? The previous bond order says aggravated robbery.
Your Honor, I do see a handgun, but I don't see what type. But there was a handgun, a black handgun that was involved.
All right. All right. Anything else, Mr. Driscoll?
No, Your Honor.
Okay. So the bond reduction request is respectfully denied. The bond remains at $150,000. All right. Who's next?
We have the interpreter, Judge. May we have Aguirre Fernando annex?
Good afternoon, Your Honor. Interpreter Enrique Portugal present.
Hello, Mr. Portugal. If you'll just let Mr. Modafo know. Oh, no, we don't need to tell the annex. The annex knows how to set up. If we'll just get the interpretation function squared away, please.
It's on.
Sí, sí lo escucho.
Okay, go ahead, Mr. Modafo.
In cause number 2022-0D01931, State of Texas versus Fernando Rojas Aguirre, announcement of council, please.
Roa King for the state of Texas.
Good afternoon, Your Honor. Joe Spencer on behalf of Fernando
Mr.
Rojas.
Spencer,
Aguirre.
would you select the English channel, please?
Oh, Judge, I'm sorry. Can you hear me? Is that proper
Yes.
now, Judge? Did I do it?
Yes, sir, you got it. Thank you very much.
All right. No, thank you, and I apologize. Good afternoon, Judge. This is Joe Spencer on behalf of Fernando Rojas Aguirre.
Thank you. And Mr. Aguirre is appearing from the jail annex remotely. He is utilizing the assistance of a court interpreter. You're scheduled for a bond hearing. Mr. Spencer, you may proceed.
Thank you, Judge. Your Honor, Mr. Aguirre is 45 years old. He's married, been married for 24 years. He's lived the last 8 years in Fabens, Texas, on Mesa Gold Street. He has 3 children, a 22-year-old, a 14-year-old, and a 5-year-old. His oldest son is a Marine veteran in the reserve with the National Guard. He is a resident alien, Your Honor, but he has strong ties here to the community with his children in school here and not wanting to risk the resident alien status. His wife works as a secretary for Fabens High School. She makes $11 an hour. He works as a supervisor for Turnkey Enterprise, which is a construction company. He makes $19 an hour, Your Honor.
Mm-hmm.
This is his only arrest that he's ever had. So we asking the court to reduce the bond to $25,000 surety and whatever, and to leave the court the balance on a PR. Your Honor, the allegations on this case is an 11-year-old outcry statement. And interestingly enough, based on the indictment, the dates of the indictment of these alleged offenses, Your Honor, it would have started when the alleged child was 8 years old. And they're all either January 1st or July 1st. The complaining witness resides in Fort Davis, Texas, and has lived there for, I believe, close to 10 years. Interestingly enough, Your Honor, the alleged complaining witness, when she was 15 years old, was pregnant by a boyfriend, had a miscarriage. Within a month later, she'd had several stints at University Behavioral Health Center, the hospital. She's been interned there. My understanding, she's got a lot of mental health issues. I don't believe, and I'm not privy to it, so I don't know. It would be interesting to know whether or not at the behavioral center, if there was any outcry from her there. The outcry that we're aware of occurred just recently, Your Honor. So this is a case that's going to be, I believe, heavily litigated.
Mhm, mhm. All right, Ms. King.
Your Honor, the state respectfully opposes the bond reduction. There's not really a criminal history. How there was a May 2010, just an assault, family violence that was dismissed due to pretrial diversion completion. Now, as to this case, Your Honor, the allegations that I did speak to the complaining witness today. She turned 18, I believe, a couple of months ago. And when I did speak to her, she did fear for her safety. This is actually her uncle. She is his niece. The reason for the delayed outcry was Mr. Spencer kind of mentioned it due to mental health. She did go through therapy and other mental health that she was suffering at the time, and that's why there is a delayed outcry. And Your Honor, we have requested the records for those, the mental health and all the doctors that she was seeing. Also, she did see, she lives in Fort Davis, and I believe, if I'm not mistaken, it's 100 miles or so from Fabian's. And she did see the defendant at a Dollar General before, and I guess there was an exchange of kind of threatening or looks from the defendant. And so she is still undergoing the mental health component from the incident in this case. And therefore, the state respectfully opposes the bond reduction.
Okay. Anything else, Mr. Spencer?
Nothing further, Your Honor. We just asked the court for a reduction in bond that he could make.
Just give me 1 second, please. Okay, just looking at the, I'm going to grant the request. However, I don't think it's as low as you're asking, Mr. Spencer, but I do think considering that your client, I think, I saw some failures to appear on, traffic citations or whatnot. The bond seems to be a little high. So I'm going to reduce it to the PR portion. I did review the previous JMAG conditions on the PR bond. That's going to remain at $10,000 PR with all the conditions that were included in that order. The cash surety portion, I'm going to reduce to $100,000. I know that doesn't quite get us, but with the nature of the offense, concerns for safety of the victim and the community, things like that, I'm going to just reduce it to 100,000. So Ms. Melendez, on the bond order, if you will just mirror everything. In fact, if you wanted to use the same type of bond order, we could do that and just reduce the cash surety portion to 100,000.
Okay, Judge, thank you.
Okay, if we need to come back, I know this one is, I don't have Odyssey. I gotta assume we're probably early on because the jailing is only 7 days on my docket. If you need to come back on the bond or any other matter, Mr. Spencer, just file your motion and request your hearing, please.
I will, Your Honor. If I could just ask the court for some guidance on one thing. Your coordinator sent me the waiver of arraignment.
Mhm.
And I don't know the policy with your court, Your Honor. Can I sign on his behalf, or do you want me to get his signature for the waiver of?
You may, as long as your client is in agreement with it. We have been doing that throughout the pandemic.
Okay.
Thank you very much.
No, thank you, Judge. May I be excused?
You may. Thank you,
Judge.
Mr.
Hope you get better.
Thank you. Does anyone else need the interpreter? Does anyone else need the interpreter? If not, so I can let Mr. Portugal go. All right, Mr. Portugal, thank you very much.
Thank you, Your Honor. Have a good day.
You too. Who's next?
Annex, may we have Crystal Guillen on page 6, Judge?
Mhm. Go ahead.
In cause number 2022-0D00012, State of Texas versus Crystal Lynn Guillen. Announcement of council, please.
Roa King for the state of Texas.
Down from Ms. Crystal Guillen.
And Ms. Guillen is appearing from the jail annex. I believe this is, maybe we were continued just 1 week out. There was some additional information on the mental health angle, I believe we wanted to go over, and have Ms. Guillen here present. I don't know, Ms. Garcia, are you here to speak on that as well?
Yes, Your Honor.
Okay, let me start with Mr. Dunham. Mr. Dunham, what else do you have for the court today?
Well, I have been in contact with Ms. Garcia. I know that prior to that, I was in contact with Ms. Guillen. Your Honor wanted her to have a plan if you were, so she would be receiving mental health treatment outside of jail. I believe that is all in place, and Ms. Garcia would be here to speak directly to what that plan would be. Ms. Garcia sent me information. She's completely current on taking medications and is currently cooperating in treatment while she is in jail. I would also just want to point out that this case is an assault, family violence, and we do have a non-pros from the complaining witness that was signed back in May. We are requesting a PR bond.
A full PR bond, okay. I forgot what I was gonna ask. I'm showing her bond at 285 cash surety. Yeah, they're all. Let me ask first, Ms. King, what is the rec in this case?
Your Honor, the recommendation is 5 years deferred and to dismiss, I believe the other 2 counts. So just to play on the ag assault. However, I do want, part of the condition is to have the intensive mental health caseload. And I did speak to Ms. Garcia about that condition and what it entails.
Is this a new rec, Mr. Dunham?
I would have to check. I believe it was on there at our last hearing last week, Your Honor.
Okay.
Your Honor, I placed the recommendation on May 12th.
Okay. All right, Ms. Garcia, what's our plan?
Yes, Your Honor. Good afternoon. Being that the client is compliant in jail, she has been taking her medication. She has been under ESN services. She has been seen by the doctor. And according to the records that I have from the nurse at UMC, she has been taking her medication constantly. At this time, I have an appointment in case she is released back to the community with one of our clinics. This appointment is with RJC, is one of our intensive services here at the ESN. And the appointment is on July 7 at 10 a.m. She is to come to the clinic, 1600 Montana, and meet with our LPC for an assessment. Based on the needs that she has, then they're gonna link her to services with the doctor and a caseworker.
Okay, all right. And where was she gonna live, Mr. Dunham? I thought previously you had told me something about an aunt or something like that.
Yes, her family, her aunt has found her a place to live, an apartment at 9544 Japonica. That's still in place as of last week.
Would you please repeat the address, sir?
It's 9544 Japonica, Japonica.
And who is that with, Mr. Dunham?
I believe that would be an apartment of her own.
Just for her own? Okay.
Your Honor, if I may.
Mhm.
I did speak to Ms. Garcia about how intensive the mental health caseload would be if she was she would have accepted if she's actually placed on the mental health caseload based through probation or through having PR bond granted. And if it's okay with you, Your Honor, Ms. Garcia can kind of explain what's the difference in that. And the reason I bring that up is because at the time of this incident, also when I spoke to the complaining witness, which is the defendant's mother, she did indicate to me that her daughter does need mental health. And at the time of this incident, her daughter was not on medication.
Yeah, I think it's the crux of our issue is that when she's not compliant, we end up with cases. So, Ms. Garcia, did you want to speak to that?
Yes, Your Honor, if I may, I explained that she is to be placed on PR bond. However, in PR bond, the probation officer doesn't follow the client that often. And I did explain that when the person is placed on MHI probation, intensive probation, the probation officer, that's what I explained to Ms. King, is that the probation officer will be following the case along with the caseworker and the program director. It's a more structured program, but for this, she would have to be modified into intensive probation.
Well, but if I'm understanding correctly, we're talking at probation, and the only thing we really have right now is PR bond, which is why I'm asking about the rec, because I didn't recall the rec being 5 deferred before. And if we're really headed there, I'm much more comfortable if we're inclined to plea to go that route. I'm not saying do that, or that, I'm just saying I'm less comfortable. I'll be very frank, Mr. Dunham. I'm in terms of the bond and having her set up with this more intensive services, even under the bond conditions. I'm not at a straight PR bond, and I just got to imagine there's very little, if any, resources to put towards a bond. Is there anything to put towards a bond?
You could put, I believe, if the bond was set at $1,000, you could do something around that.
Yeah, I'm not there. So I can tell you anything else.
Well, Your Honor,
Okay.
I would request if you could split the bond and lower it, and maybe her aunt can come up with more, but the last amount I was given would be that, but
yeah,
a reduction of some sort split would be certainly preferable to no reduction.
When's her trial?
Set for
August or July, or August 12th. It's a backup trial.
Okay. All right. So her bond is there anything else on the bond? Thank you, Ms. Garcia, for your information.
Your Honor, if I may, I misspoke. It's July 14 and 15.
She's on that date. Okay, so it's coming up. Well, I'm still not where we need to be. I'm at $100,000 split, 50,000, 50,000 cash surety, 50,000 PR. Weekly reporting, may not leave El Paso County, must reside at the address that you indicated, may not change her place of residence without court permission. She is to possess no weapons, no firearms, no ammunition. she's got a curfew from 9 p.m. to 6 a.m. unless she's working or going to school. Use no illegal drug or alcohol, subject to testing, may not come within 200 yards of the victim or the victim's residence, may not have any contact with the complainant, not any direct, indirect, no text messages, email communications, anything like that with the complainant. But more importantly, she is to maintain all mental health conditions that I guess have been described by Ms. Garcia, this RJC intensive treatment through EHN, includes, yes, appointments, meds, screening. I don't know if she makes it to make it out of that appointment. We're really on the heels of the trial date. So let me think what else. I think that's it. No new offenses and can't leave El Paso County.
Yes, ma'am.
Anything else?
Nothing
No,
further.
you're-
Okay, thank you very much. Thank you, Ms. Garcia.
Thank you. May I be excused?
You may.
Thank you.
Who's next?
Bottom of page 6, Judge. Annex, we have Melissa Maldonado.
Go ahead.
In cause number 2022-0D0-1967, State of Texas versus Melissa Maldonado. Announcement of counsel, please.
Barbara King for the state of Texas.
Greg Anderson on behalf of Ms. Maldonado, ready to proceed, Your Honor.
And Ms. Maldonado is appearing from the jail annex. We're scheduled for a bond hearing. Mr. Anderson, you proceed.
Thank you, Judge. Judge, Ms. Maldonado is 35 years of age. She's born in El Paso, has lived here her entire life, and all her family members are here, including her mother, who she lives with, and I believe was living with at the time of this, the offense, alleged offense. Again, she's an American citizen. She has no reason not to be present at any of the hearings and the like in this case, and will be present. She previously had hearings on misdemeanor offenses, as well as what were in the jail magistrate court were either misdemeanor or felonies, but they're unfiled as of last year. The jail magistrate looked at those as well as looked at all misdemeanor offenses in this case and agreed to provide Ms. Maldonado a PR bond, and of course, subject to what you choose to do. Requesting, Your Honor, in this case, that she be placed on PR bond. The underlying allegations in the case in front of you will be contested heavily in light of various circumstances that I've become aware of. And so, again, Your Honor, just because, particularly in light of the fact that the bond in this case is largely a requirement for the client to be present, I think everything points to the fact that a PR bond would be sufficient in this case. That's what we're requesting, Your Honor.
Okay, Ms. King.
Yes, Your Honor. The state respectfully opposes the bond reduction due to the criminal history. There's quite a bit of criminal history that involves theft. It started from 2012 with a misdemeanor theft. Then I believe 2014, there was a state jail theft of property. She was placed on deferred probation. 2015, another theft between $1,500 and $20,000, and she was sentenced to 9 months in confinement. There's another theft, a state jail in 2015, and that was to run concurrent with the previous theft of 9 months in confinement. There's also a tampering with government record. That's a conviction, I believe 6 days. That was a misdemeanor. There's unauthorized use of vehicle and a theft of property, a misdemeanor again in 2021, June. There is also resisting. I believe this case, that's May 2022. And we have another theft right now in a broker of a habitation. And so, Your Honor, due to the charges that we are pending on right now, she does have the same past history of the same charges.
Your Honor, may I respond to that?
Yes, sir.
All of the charges of this year, 2022, actually arise out of all the same sort of incident. Prior to that, in June, I believe, of 2021, there were some of these additional charges which were referenced by Ms. King. Those have never been brought forward a year later and likely will not be. And back in June or thereabouts of 2021, when I was first appointed in this case, my client was placed on PR bond. And again, it's my understanding, and as represented by PR bond people this morning, or rather yesterday when we did the misdemeanor bond hearing, she complied with all the PR bond conditions since June until these most recent charges. Again, the most recent charges, I know you can't litigate them. We can't litigate them at this time in front of you, but they will be hotly contested. And as a result, in light of her compliance with PR bond conditions from June of last year, wherein she was completely in compliance, and then June of last year, those charges looks like they're going to go away. It's been years, and I don't think they're valid. I do respect Ms. King's reference to previous offenses, but again, I don't think that should be what should prevent my client from receiving a PR bond in this case, as it's really only to make sure that she be in court for these charges.
Your Honor, if I may respond just briefly, an update on the P file.
Yes.
The P file 2021-P file 06851 is charged in unauthorized use of vehicle. However, I do see that it was on today's grand jury calendar, and the charge was actually changed to a theft of property between $2,500 and $30,000.
Is that supposed to be a separate incident from the ones involved here?
Yes, Your Honor.
So like separate date of incident?
Yes, Your Honor.
Your Honor, and I think the reason it's finally come to head is since my client has been held in custody, I filed a motion for examining trial. Of course, I know very little about that because apparently it did get indicted, if I'm understanding that. But so I'm assuming it's going to come to you as well. But again, those are for an event which allegedly took place a year ago, and why the state waited an entire year to get it to this point, I don't know. I did request that they look at it by filing a motion for examining trial because my client was in jail. I guess that's why it was brought to a head finally.
All right, anything else?
Only, Your Honor.
Okay.
Only, Your Honor, I'm sorry. Only, Your Honor, that I think those charges actually, she did receive a PR bond on them. Because we had the hearing yesterday, which included those charges. I don't know if that PR will apply to the new indictment or not. We'll have to look at that. But again, the jail mag did provide PR bond for those charges.
All right. For now, I'm going to deny the bond reduction. However, Mr. Anderson, it looks like if we have this new case coming up, if that is going to kind of bring all our cases together, if you want to re-urge or refile and request a hearing, I will absolutely reconsider. Okay.
Thank you, Your Honor.
Thank you very much. Thank you, Ms. Maldonado. Who's next?
Top of page 7, Judge.
Go ahead.
Next, we have Jesus Morales.
Roa, did you get my email about Jesus?
No, I did not.
Let me check.
And it over.
Are you ready?
Yes, Judge.
Go ahead.
In cause number 2021-0D00769, State of Texas versus Jesus Manuel Morales. Announcement of council, please.
Roa King for the state of Texas.
Your Honor, Leonard Morales on behalf of Mr. Morales.
And Mr. Morales is appearing from, Jesus Morales is appearing from the jail annex. We're scheduled for a bond hearing, Mr. Morales.
Judge, my client, Mr. Morales, has been in custody now since March 17th, approximately. He's under a $100,000 bond that was set by the court, I believe, for a failure to appear sometime in 2021 for these allegations. At this time, Your Honor, my client lacks sufficient funds to post that size of a bond. I know that the court normally sets those kinds of bonds to assure the appearance of the defendant, and also to tell the defendant or communicate to the defendant in some way that these are serious matters that to attend to. But nevertheless, Your Honor, I think although we're Ms. King and I
That's quite a bit.
work out the terms of a potential plea, I believe that at this point, my client should be subject to at least some kind of bond reduction, considering the time that he's been in custody on this matter, Judge. This is a state jail felony, Judge. It's not the crime of the century, obviously. And my client, again, has been in custody for some time. If he were released on bond, Judge, I have two individuals locally, Miss America Herrera, who is his sister, Brenda Morales, who's his mother, they both reside in San Elizario. He can provide the address specifically to pretrial services, Judge, so that they can investigate that. I'd rather not put that on the record. But nevertheless, Judge, I think my client is no longer a flight risk, and that he can be compliant with terms and conditions of a bond to ensure his appearance at court.
Okay. Ms. King?
Yes, Your Honor. Actually, I did send the plea paperwork on June 6th. It was 180 days. 180 days, yes, on this case. And it was a 1244A. That paperwork was sent to you, Mr. Morales, on June 6th. I can resend them.
Was it wrong? Ms. King, I don't think I got it, but could you send that to me again?
Yes.
So I was just looking over in terms of the bond. I mean, I was just looking over the issues that we had on PR bond. And I don't know if it looks like PR bond had attempted for quite a few months and made contact with his mother, all kinds of things. And he was just MIA and stopped reporting. I mean, he was on PR bond. So, we're set for trial, whether he pleads or not. I mean, sounds like a reasonable rec, but we're set for trial on the 14th and 15th. So I think the bond is appropriate. 100,000, the request is denied.
Very well, Judge. I'll let me see, did I get I just want to make sure, Judge, that I get the email from Ms. King. I think
I just forwarded the email to you.
Okay, great.
All righty. If something should come up, we have the final hearing plea deadline that Tuesday before. So if you intend to not look at, if we're not really looking at a plea and there's something else, I'll consider it then, Mr. Morales.
I did get them, Roa, just to let you know. I just got it right now. So
sounds good.
Mr. Morales, I'll be out to see you. I can't tomorrow, but I'll be out Thursday. Okay.
Thank you very much.
All right. Okay. All right. Thank you, Judge.
Anyone else? No? Yes, we can take care of Mr. Hernandez next. Go ahead.
Thank you, Judge.
Take care.
Annex, may we have Davila Eduardo?
Let me write out.
Page 5, Judge.
Good afternoon, Your Honor.
Hey, Mr. Hernandez.
Counsel.
Easy go.
Clause number 2022 0D00735 and 2021 0D02285, State of Texas versus Eduardo Davila. Announcement of council, please.
Roa King for the state of Texas.
Pedro Hernandez, with the Mental Health Unit of Public Defender's Office, ready to proceed on behalf of Mr. Davila, Your Honor.
And just so I'm clear, and Mr. Davila is appearing from the jail annex. I only show him being held on the case ending 2285. He has $100,000 bond there. I think he has a straight PR already on 735. Is that what you show, Mr. Hernandez?
No, Your Honor. So I think I showed 30,000 on the 50,000 on the arson and 30,000 on the theft, Your Honor. But that might be old. The court may be correct since it was an added charge at a certain point.
Okay, I'll ask the clerk just to tell me what the correct bond amounts are, but you may proceed on your bond hearing, Mr. Hernandez.
Yes, Your Honor. As the court realizes, Mr. Davila is a mental health unit case. And the reason is because as a child at the age of, I believe, 14, he was involved in an accident which caused, I believe, some type of traumatic brain injury. As a result of that, he's suffered a lifetime of auditory hallucinations. He receives a monthly check, not from SSI, but from the insurance company. It's $1,100. These auditory hallucinations can encourage him to do things when he's on the right medication, like right now. He seems rational and coherent. I've been able to confer with him, Your Honor. And so I understand the court, is required to look at things such as community safety and the like. And if we take a closer look at these two incidents, without getting into all the facts of the case, it was clear my client was having a psychotic break, and I believe not at that time on his proper medication and taking his proper medication. And I think he may be having a problem right now with getting his proper medication because the jail doesn't provide all the medication he gets on the outside. Your Honor, we're asking for a full PR or at least as low as possible, with the understanding that I've even received one of the alleged complaining witnesses is a sibling, and I've even received medical records from siblings, and the ones that I've had contact with or have had contact with me and reached out to me do not believe that the proper place for him is in jail or in prison, but rather getting treatment on the outside, perhaps through a facility of some type. And Your Honor, so this is just an odd situation where it almost it seems unfair that because as a child his mental health or his neurological health is so damaged that and I'm sure the state right now will probably list a number of incidents with the understanding that he's not. I don't think he'll always be a danger to society, Your Honor, or that he even is now. He just needs the proper care and monitoring, Your Honor. And so we would ask for PR with the mental health unit, with EHN doing the oversight if need be, or whoever the court wishes to use. But it's just a sad situation where my client is in his own way a victim himself, and driven by these auditory hallucinations, these voices. And when properly medicated, the voices are reduced dramatically. But if for any reason they're not properly medicated, then they become louder and more demanding and commanding, Your Honor. With that said, Your Honor, I'd request, if not a full PR, as low a PR as possible. I've had a brother call out or actually called me and also get me medical records and stuff. I don't believe the family wants him incarcerated, Your Honor. They're trying to get him medical care.
Mr. Hernandez, I got kicked out. And the last thing I heard was that he received proper care. Okay, I just got reconnected. But I think I hear the gist of what your concern is. I was attempting to look at Odyssey while you were speaking to see he is on a $50,000 PR bond on the arson. Unless that changed after March of this year, the jail magistrate put him on a $50,000 bond there. I was attempting to look at the bond order on the theft, and it's got to be a PR violation. Was there something? I obviously missed something, but
the gist of it is this, Your Honor, that as a child he suffered in an accident. He's not responsible for an injury that is now left him for the rest of his life suffering from these auditory hallucinations. And so I'm sure the state will be able to show, different incidents at different times whenever for some reason or another he missed his meds.
Mr. Hernandez, let me get to the point. If the crux of the concern is the mental health concern, what is the plan if he gets out? Because I think, that they're telling me here is that the PR violation was for picking up the arson and not reporting. He had previously not reported. And so how are we going to make sure if he's not even getting the meds he needs now that he's in jail, how am I going to have him on track if I give him or lower the bond or give him a PR bond? I'm not sure.
I don't know. I mean, when I've talked to him, he seems rational right now. I think most of the meds he's getting are correct. I think there may be one medicine that's not correct. I believe my client may want to address that very quickly, if he may.
Sure.
Mr. Davila, is there a particular medication you're supposed to be getting on the outside that you're not getting here?
No, so once they gave me in here, they're very good. There's just one pill, Hiptoco, that's part of some food treatment. But the rest is mental health medicine.
Okay.
About me doing such things in the world, no, not the first time. That's why I'm saying the truth.
Okay, and don't say anything else. But did you say Wellbutrin is the one you're not getting here? Or?
Yeah.
Right, and that's what I thought. There's one medication, Your Honor, and I think it's my understanding the jail doesn't do certain medication because they're afraid it'll be distributed within the jail. I believe that's it, if I understood the explanation correctly. But he can get it easily on the outside, Your Honor. Your Honor, and I'm sorry, Ms. Garcia got off because she would have been a good person to talk to. The idea would be to get a prescription going, but when he's on the outside, he has providers, Your Honor. He actually has income, $1,100 a month that he's getting from the insurance since the age of 14 because of this situation, Your Honor.
Sure.
And the court could set up whatever monitoring it would like. I think he would be ideal for the ACT or the FACT program. If the court wants to reset for a week, I could see if they have an availability. As the court knows, the ACT and the FACT programs, they can monitor medication intake multiple times a week just to make sure that he gets it. The thing is that I don't know if you can do that on PR. It's the same problem the other young lady was having. I mean, there's intensive ways to do this, but not necessarily intensive ways to do this while on PR. But he could easily hook up with EHN or go back to his regular provider, Your Honor.
Okay, so Ms. King, what is the rec on his cases? I know the arson is newer. What is the rec and, oh shoot, what was my other question? And when is our trial set? Are we tracking the new case?
Your Honor, the recommendation on both cases is 5 years TDC. Jury trial is set on the 2022 case. I see February 3rd of 2023, and this is not the first bond hearing. Let me check on the 2021 case.
Has he been to prison before, Mr. Hernandez?
He may have, Your Honor.
He does have, I believe, 3 or 4 previous pen trips. Both cause numbers are set currently for February 3rd, 2022, or 2023.
Okay.
And if I may suggest, Your Honor, I think that clearly, and I think this is what the family's trying to tell me, sending him to prison isn't working. In fact, they sent me his prison medical records. There has to be, that's why I say he would probably be ideal for the FACT program and then the ACT program, because they could monitor him every other day just to make sure he's staying on the medication and everything is going right. There can be constant testing. I mean, he needs that kind of intensive program, and probably for a lifetime. But just sending him to prison over and over again, it's just clearly not working, Your Honor.
When were our, I've got to imagine there's an extensive criminal history. When are our pen trips? When are our prison stints, Ms. King?
Your Honor, so we have 19. Let's see, we have a DWI 3rd or more. That was 5 years confinement in 2014. And we have robbery. I believe that was a lesser included offense. He was, let's see, date committed 1997. And this, he was sentenced 2002. There's also 1995 for an aggravated assault, 3rd degree. That's
Those
another
are all pen trips?
Yes, and there's another state jail 1995 for theft between $1,500 and $20,000. And he does have very extensive criminal history since 1993 to now.
Yeah, I'm sorry, Mr. Hernandez, I'm going to deny your request. The bond will remain the same.
Yes,
Thank you,
Your Honor.
Mr. Davila. And then we need Villanueva still, see?
If we could very quickly, Your Honor, just to
Okay.
clear up some matters.
Okay, Annex. Thank you, Mr. Davila. We're done with your hearing. If we could have Ms. Villanueva, please.
And Ms. King, I'll reach out to you later to see if we could try to come up with a solution that actually works for this.
Sounds good, Mr. Hernandez.
Are those the only 2 you have, Mr. Hernandez?
Yes, Your Honor.
Okay, let's go.
In cause number 2020 0D06556 and 2020 0D04363, State of Texas versus Rafael Villanueva. Announcement and counsel, please.
Well, King for the state of Texas.
And Edward Hernandez on behalf of Mr. Rafael Villanueva, Your Honor. Your Honor, and I don't want to take up a lot of the court's time right now. The Ms. King did send us plea papers, and it's there was a 20-month sentence on the terroristic threat case. And I think I believe it's my mistake and it's the sheriff's mistake, but I asked the sheriff how much time my client has, and they gave me 571 days. But we did the math, and my client's the one that caught it. When you do the math, that's like 19 months. But the problem is he stopped getting credit at a year because the court PR bonded him out on that other criminal mischief. We were hoping to see if we could get that reduced to 12, to just make it a 12-month sentence because he has 12 months instead of the 500 day. And what I'm saying is, clearly when I gave the sheriff's, the jail, a specific case number and said, what's the credit on that? And they gave me the credit for the other case, which is the 20-month case where he's been here doing that time on it. But what my client tells me is he absolutely, he's sure he has the 12 months because that's when the court PR bonded him out. So if we could get a correction made, my client would also like to ask Ms. King with the court's approval, if we could make that a misdemeanor, because the damage was never over $400, you know. So, and finally, Your Honor, my client, I did meet with him early this morning. I was hoping that if he could, in the meantime, since we're basically doing a time served rec, the concern is if he pleads to 571 days, that they're going to realize that he only has 1 year, that they'll then want him to do the other 100 and some odd day. You know, he'll be here another 6 months or whatever, trying to finish off the 571 days, because he really only did 1 year before he got PR bonded out on the criminal mischief. So if Ms. King would be willing to do some edits there, I think we can finish this, Your Honor. And my client's wondering if he could be allowed out on PR bond while we correct that.
Okay, Ms. King.
Since he has a bond hearing today. Anyway.
Sure.
Your Honor, well, this is news to me. As for the misdemeanor for a criminal mischief, I'm not willing to agree to that because he does have previous history of criminal mischief. They were misdemeanors. However, it seems like this is a repetitive.
Let me ask, it sounds like Mr. Hernandez said something about the value of the damage, or, I mean, is that an issue? Sounds like it's an issue.
My client says that earlier, before both I and Ms. King came on this case, that the state had actually admitted that they could not prove any damage over $400.
What's the damage on the criminal mischief? What allegedly? I haven't seen that.
I think he allegedly kicked the car or scratched the car or something like that.
It was damage to the vehicle.
Do we show anything about the value on that, Ms. King?
Your Honor, that's what I'm trying to pull up.
Okay. So with that said, with respect to the bond, no, there's going to be no change in the bond. I know we're really probably closer on the disposition end in terms of a plea or something else, but I think we have an August trial date. So the bonds have been, you know, where I think they should be at this point. And so I think what you're saying is on the terroristic threat, it would still be 20 months. Is that right, Mr. Hernandez? And then you're asking.
Yeah, it's still 20 months of a terroristic threat, but he only did 12 months before he got PR'd out.
The PR bond, right? So he was
on the other one. So you don't want to leave it at 570, which is what the sheriff's told me, 571 days. I think my client got that. No, I'm not at 571 on the criminal mischief. It's 571 that I have on the terroristic threat.
So, Ms. Melendez, is that right? Does he have two different sets of credit for these cases? Because my docket reflects 569, so it would probably be 571 on each case.
Yes, Judge, that's what I'm showing here. The 573 is what I'm showing here.
573, and that's both the terroristic threat and the Villanueva and the criminal mischief.
I am running the report, Judge, just to verify.
Sure.
Your Honor, as to the restitution amount, so what I see in the notes, that there is actually two documents. We received one of the documents back in February of 2021. We followed up again for the second document, I believe June of this year. The first doc, which I do see the receipt on the first one that we received. That's the one for 450. But as of right now, I don't feel 100% confident to go ahead and just agree to misdemeanor without clarifying.
Sure. And so it's been brought to your attention. So if you'll look into that. With respect to the bond, though, the bond request is going to be denied. The bond is going to be the same. Ms. Melendez, do we have the report on the time credit?
For the terroristic threat is 573.
Okay, and for the criminal mischief?
Yeah, it's also 573.
So Yeah, I mean.
Which is kind of odd considering he's been a PR bond, but okay. We wanted, and if the court, if in the final order, if the court can order that he gets full credit for that time or something,
Correct.
Just to make sure he doesn't have to redo that time. Your Honor, if I think I can follow up with Ms. King and maybe we can, we're going, if I may speak to my counsel or my client, Your Honor, Mr. Villanueva, I'm going to reach out to Ms. King and we're going to clarify what the value of that damage is to see if we can get it down. Okay.
Sounds reasonable.
Is that okay, Ms. King?
Yes.
Thank you very much. Thank you, Mr. Villanueva. Thank you, Mr. Hernandez.
Am I excused, Your Honor?
You sure are.
Thank
Who's
you very
next?
much.
Page 7, Judge. Annex, may we have Pace, Donovan Pace?
That Mr. Pace?
Yes,
Okay, go ahead.
In cause number 2022-0D01342, State of Texas versus Donovan Deron Pace. Announcement of council, please.
Roma King for the state of Texas.
Good afternoon, Judge Ruben Ortiz on behalf of Mr. Donovan Pace.
And Mr. Pace is appearing from the jail annex. We're set for a bond hearing. Mr. Ortiz, I show him at 25,000 cash surety. You may proceed.
Yes, Your Honor. My client's a United States citizen, Your Honor. He's single. He graduated from Andrews High School. He obtained an associate's degree in culinary arts. He had worked previously as a caregiver at Caregiver Caring Partners. He was employed there for a while, and then he's also been employed at. He was previously employed at Global Enterprise as a telemarketer, Your Honor. I want to say that. Let me look at his criminal history. He had a federal case, Judge, of giving rights to individuals that were undocumented, basically, Judge. In federal court, he was sentenced to, I think, 8 months or something like that, Judge, in Las Cruces recently. And what's happened is, for whatever reason, Judge, for whatever reason, he was writted over here. I don't know, and I don't think Ms. King writted him over here. I don't know how he ended up over here. We don't know how it is at the feds. And I talked to his federal defense attorney, and she was shocked also. She couldn't. This was very unusual. The way that typically what happens is when you're sentenced in federal court under federal custody, then you finish up your time over there, and then once they're done with their time over there, then they'll the state of Texas will have their opportunity to pick him up and then have him be brought over to you, Judge, and then we could deal with the bond issue. With him, it was kind of backwards. So he's in limbo right now, Judge, with this case. So he's not getting any credit for the federal time right now as he sits there. I think Mr. Donovan has been over here now from Las Cruces for about 30 days or so. And it took us some time to finally figure it out. And I finally set this for a bond hearing, Judge. So I think for now, the only thing I'm requesting, Judge, is he needs to be released from this somehow released from this warrant. So we can need to put him on some type of PR bond, and then he's going to be the feds will take custody over him, so he can finish his time in the federal prison system, Judge.
Let me ask.
So for now, I'm requesting a PR bond, Judge, until yeah.
So I'm a couple of things. I'm showing days in jail 136, but maybe that's from a prior jail stint. Ms. Melendez, do you show some type of hold or detainer or something from the feds?
Yes, Judge, there is a hold.
And when was he booked here? Because it's been more than 30 days, no? I mean, I'm showing 136. I don't know if that's all right. In the meantime, Ms. King, you can go ahead.
Yes, Your Honor. As the state respectfully opposes the bond reduction, there is a criminal history. Actually, there is a wanted warrant that was issued out on February 14, 2022. There is a July 2021 conspiracy to enter and transport or harbor aliens. That's the federal case, and smuggling aliens. I believe I see it 5 years bail supervision on these 2 counts. I did place a recommendation. There has been a recommendation since June 11th, which is 7 years deferred with deadly weapon findings.
Well, I mean, unfortunately for that, Your Honor, I mean, he's in a bind, and my client would be more than happy to handle this case, Judge. But the way it's being, this is not, I don't think this is the way to handle it. I want to say that the appropriate way to handle this case, the allegations are that my client threw a rock at somebody, basically, Your Honor, in this case. This isn't one of those cases where, it's a firearm or anything like that, Your Honor, that's being alleged.
What's the alleged date of offense? I mean, I see it's a 2022 case, but what's the alleged date of offense? And is that right? Throwing a rock? What kind of injuries are we talking about?
Your Honor, it was a rock at 2 females, and they are the complaining witness. I also do see unlawful carrying. It's a misdemeanor, and that one is actually date of offense it's probably how he was picked up.
Your Honor.
Yes, ma'am.
Yes. May I share my screen? I do have a writ from that the marshals actually went ahead and submitted, and for us to actually release him to them, to the feds.
What's the date on that?
It is for April 15, 2022.
Okay. All right. What's the date of offense on our ag assault?
Your Honor, I see January 23rd, 2022.
Okay. When is he set for trial?
I see February 24, 2023.
All right. And did we ever have him? Well, I mean, honestly, I think Ms. King, if you wanted to finish up with your response on that.
No, Your Honor, that's all I had.
Okay, so I'm going to grant the request for a full PR bond. So he will be a $25,000 PR bond. We'll have just regular reporting requirements. I know that might get complicated if he's in custody over there. I'm not sure what the status is, but he will be required to report once a month by phone, have no contact with the complainants, possess no weapons. So I'm not sure, Mr. Ortiz, what's going to happen, over there. He gets released, but he still will have those conditions. And if he's released from custody, he is to then remain in El Paso County, may not leave El Paso County without court permission. He'll be subject to curfew, all those standard conditions. To the extent that you can assist him, if he remains in custody over there, if PR Bond starts asking questions, things like that, just update with the status. And Mr. Pace, you're going to be required to comply with all those bond conditions immediately upon release from the feds. Okay. And so for our purposes, Mr. Ortiz, I mean, if we're not looking at a trial until 2023, I'm going to waive his check-in requirements, but understand that the minute he's released, as soon as you become aware of that, he has to comply. So
absolutely, Judge. And I'll negotiate with Ms. King on this case, Judge. I think we could maybe resolve it.
Sounds good. We have a window. I just don't know if ultimately it ends up being enough of a window, but we'll see. We'll see what happens.
Thank you very much, Your Honor.
Yes, ma'am.
So as per SB 6, because of the offense, there has to be a cash surety
component.
It can't be a full PR.
Okay. So then it will be.
What do you think? A $1,000 cash surety?
1,000 cash surety, 24,000 PR with all the same conditions. Okay.
Thank you, Your Honor.
Thank you so much, Your Honor.
Thank you, Ms. Melendez. Thank you for reminding me. All righty. Okay, thank you, Mr. Pace. Who's next? Mr. Ortiz, if you don't have anybody else, you're good to go.
Thank you so much. Nice to see everybody. You all take care.
Take care.
Annex,
Bye.
may we have Rollins, Randy Rollins?
Hi, Judge.
How are you, Judge?
I'm all right.
Qué bueno.
Sorry to keep you waiting. It's a busy
It's
day.
part of the business, you know that.
We're almost done. All right, is that Mr. Rollins? Let's go.
In cause number 2020-0D0-2293 and 2020-0D0-1714 and 2020-0D0-1328, State of Texas versus Randy Rollins. Announcement of council, please.
Carl King for the state of Texas.
Maximino Dalen Munoz for Mr. Rollins. We're ready to proceed, Your Honor.
And Mr. Rollins is appearing from the jail annex. We're scheduled for bond hearings. I show them each at 100,000. Mr. Judge Munoz, you may proceed.
Okay, Your Honor. The last time we were here for something else and a couple of weeks ago, but on June the 4th of 2020, my client was supposed to appear before your court. We went on a motion to reduce bond that was filed on May 6th of 2020, Your Honor. So at that time, he lives in Carlsbad, New Mexico, and complaining witness in the case is last time she resided here in El Paso. I have no idea where she resides now, because later on when you asked me to contact him on November 23 of 2020, I was informed that he had picked up 3 felony cases up in New Mexico. So when he was supposed to report for court, he was already incarcerated in New Mexico. He has remained incarcerated in New Mexico until now, and he has been here in El Paso County Jail for approximately 124 days. But before that, he had already done, I believe, 6 months of incarceration, but I could be wrong on that. And if he's allowed to go back, he has somebody in Carlsbad where he can live. Also, the parole board of the state of New Mexico has set up something for him to for rehabilitation purposes due to his consumption of illegal substances. And as far as I know, the complaint witness in this case, I don't know if she's still on board or not, but that would still leave Mr. State Jail, which would be the possession of penalty group 1. Because the aggravated assault with a deadly weapon and the other one with I believe they're connected, John. They happened on the same incident, if I remember correctly.
Okay. All right, Ms. King.
Yes, Your Honor. The state respectfully opposes the bond reduction based on the extensive criminal history. Without having to go through the list, it's around 14 pages, and it starts all the way from possession, drug cases. Let's see, there's also New Mexico cases. A lot of them is also failure to report. We have fraudulent credit card. And I have actually, there has been a rec since 2020, and I've always honored that rec. And that was 5 years deferred on the drug charges, dismissed the ag assault weapon, and plea to a lesser or reduced to an assault for the injured child. And Your Honor, just, it seems like the defendant doesn't, once he's out, it doesn't appear. And after assessing the case even more, I'm kind of hesitant and also because of the new charges that he picked up from New Mexico, I'm a little bit hesitant to honor the new rec, which is the probation rec.
Right. Does he
Your
have?
Honor, if I may,
Mhm.
we were about to plea Mr. Rollins to that wreck last time, and of course, it didn't happen. I would love the district attorney's office to keep the wreck, and so we can finalize this cases.
When is he set for trial?
He's set for trial, let me see. He's set for trial way into the future, Judge,
September 30th, 2022.
September 30th.
Oh, that's not too far. Okay. No. The bond request is denied. The bonds will remain the same. So if we're working on some other disposition, feel free to do that. And if you need to address the court on anything else, please request your hearing, Judge.
Okay. I
Thank you
even
very much.
send an email to the prosecution and see if they will honor it, and we can take care of everything.
Yes,
Okay?
sir. Thank
Okay.
you. All right, who's next?
Next, may we have Silvas, Jesus Silvas?
Go ahead.
In cause number 2022-0D00195 and 2021-0D00055 and 2020-0D04211 and 2022-0D00875, State of Texas versus Jesus Miguel Silvas. Announcement of council, please.
King for the state of Texas.
George Driscoll for the Public Defender's Office, covering for Brent Stevens.
And Mr. Silvas is appearing from the jail annex. You may proceed.
Your Honor, Mr. Stevens had indicated that the court had heard a bond reduction on Mr. Silvas's case on the 21st of this month, where he had requested that the court modify his current probation to the mental health unit and asked for PR bonds on the two new cases. And he had left me with indication that you wanted more information about his mental health treatment plan upon release. That since then, Mr. Stevens had contacted Roxanne Garcia Juarez, screening him for the MH unit, and that he is scheduled for an intake with Takumi at it looks like July 1st at 10 a.m. His girlfriend has been made aware of that appointment, will ensure his travel, and that he has also been provided with a 10-day supply of medication that has already been filled at CVS for his approval. And Miguel is going to live with his girlfriend and the mother of his 6-month-old child, Margie Rios. She's not a complaining witness in any of the pending cases. And we would ask the court, I guess, yes, at this point, we would ask the court again for a personal bond in his cases.
Okay, Ms. King.
Yes, Your Honor. Your Honor, the state respectfully opposes the bond reduction. As defense counsel stated, there was a bond reduction June, I see 22nd, but that was denied. There's a criminal history, theft of property. It started from juvenile. There's also possession issues. I personally have not received any paperwork regarding mental health. There's another theft of property in 2013, criminal trespass, assault family household impeding breath. That was in 2014. He did receive 150 days to a lesser charge. And there's again the possession PG 3, less than 28 grams. That was a conviction in 2014, 100 days confinement. There's 2016 aggravated assault with a family household with a weapon. And I see that was dismissed. And the complaining witness in this case, it does not feel comfortable if the defendant is actually granted the bond reduction. The complaining witness is
that the brother-in-law?
yes, he is handicapped. And he did state to our office that the defendant did know that at the time. And therefore the state respectfully opposes the bond reduction, Your Honor.
Your Honor, may I respond, please?
You may.
Your Honor, our office had gone at great lengths to prepare the release plan, and Miguel has mental health services set up at the Isleta del Sur Pueblo MH services at Sacred Connections, as well as substance abuse treatment at the Circle of Healing in Isleta del Sur Pueblo. He has employment available to him as a groundskeeper at the Isleta del Sur Pueblo as well. He is able to return to that workplace, comply with the conditions of bond, and I guess avail himself of the services that the county has to deal with both his MH and substance abuse concerns.
I guess,
Your Honor,
yeah.
if I may, on really quickly on the probation case, the theft of property ending in 4211 and 0875, there on the violation notice, I do see that there is a failure to report other than other violations that are listed.
Right. I saw it was like 1 month, and they reestablished probation, I think, the following month. And so my concern is more geared towards this. I understand that, there is a mental health concern here, but he was probated in July of 2021, and we almost immediately start having the rearrests. We almost immediately start having issues. And so I don't think we were addressing the mental health concern when he started probation. I'm not sure why, but, so that could be, he was kind of under a set of conditions where he may not have received the structure and the assistance to be successful, but nevertheless, we still come up with two violent offenses, an assault against a public servant and an assault of a family member. And that is where I'm concerned, Mr. Driscoll.
Yes, Your Honor, and we are aware of the court's concern. It appears that Mr. Silvas has gone through the competence process several times since this case has been pending. It's abundantly clear that he does have these MH concerns that, as a defense, we feel contributed to the instant criminal episodes, as well as his difficulties on probation. We feel that given the proper treatment plan and availing him of the resources, that he could be a successful probationer. And we have no doubt that he would be a successful on bond as well, if those needs are addressed and provided for him.
Ms. Carla, on the case summary for Mr. Silvas, the recommendation is that he be ordered to go to anger management and then screen for the MHI caseload. I mean, I'm not seeing anything else regarding, is it that we just didn't have enough time with him to get a better handle to know if, is probation wanting to give him a chance on probation?
I think
Hold on, Carla, Miss King, what's the rec? Do you have a rec on the new cases?
No, Your Honor, I've been waiting for the probation recommendation on the other cases.
Let me hear about that, Carla.
So, Your Honor, I was just double checking just to make sure, but initially when he pled almost a year ago, there was no indication about mental health. It wasn't set, or I'm checking myself. We didn't put on there to have him screened or anything like that. And I mean, overall, yes, I understand he picked up these 2 new offenses, but he has remained in custody since then. There was 1 failure to report. I guess in 5 months, he didn't work on community service or complete anger management.
Mhm.
But I do see Mr. Driscoll's and Mr. Stevens behind the scenes. I'm trying to get him that one appointment. He does have that appointment on Friday. I think that's July 1st. He does have that appointment at 10 a.m. And I mean, just basically from that one appointment, we would have to wait and see what level of care he would fall under to see if he would even qualify for the caseload through probation.
Right, and that's
But,
on probation cases. So on his, all of the cases are set for bond hearing. So on the probation cases, he's on deferred, he's entitled. He has no resources, right, Mr. Driscoll? He's been in there for a while.
No, Your Honor. He does have the ability to gain resources were he to be released, as he has an employment opportunity, but unfortunately his family does not have resources for bonding at this point.
So on cause number ending 875, that will be granted. It will be a full PR bond unless this one's on the list and they're gonna tell me, I don't remember. Is assault on a public servant one of those that requires a cash surety? Miss Melendez or Miss King, or because I'm not in my office with my handy list.
I'll go ahead and look that up, Judge.
Thank
Your
you.
Honor, I may really quick, I did fail to mention that there is a, a case waiting to be screened, criminal mischief, just a misdemeanor, date of offense, February 24, 2022.
Okay.
And let's see.
I think what was outstanding also, Carla, was the ability to screen him while he was in custody. That's a no, not a possibility, right?
No, Your Honor. They verified with Ms. Roxanne.
Okay.
Audits.
Okay. Oh, yeah. So,
Judge, Judge, it's not on the list.
Okay. So then I'm going to go ahead and grant the request for straight PR bonds on the 2 new cases. And then do we have motions pending at all on 55 on the 2 probation cases or no?
Yes, Your Honor.
Okay. So then we're going to leave those motions pending. And I guess we can just release him, no? Ms. Melendez, on the 2 probation cases?
Judge, on the assault for a public servant, it's not eligible for a PR bond.
Yeah, that's the one I'm concerned about.
While released on a bail or any type of community supervision.
So if he's on probation, we can't give him a full PR on that offense. That's what it is.
Correct, Judge.
Is it same for the AFV with a prior, the 0195?
It's any assault.
Yeah.
In
So
section
that's-
22.1.
Yeah, that's gonna, so we're knocked out on those 2 anyway.
Your Honor, would you consider setting a nominal cash or surety amount to satisfy SB6, like $100 or something along those lines, as the court's intentions would include?
So I'm gonna put a 1,000. They're gonna be $1,000 on each of them. 9,000 PR for each of the 2 new cases. Is there any restriction in that same vein, Miss Melendez, on the probation cases? Do those also have to have a cash surety component on the probation cases? That I'm not thinking.
No, Judge, unless they're assaults.
Okay, so I'm gonna just release to streets on the 2 probation cases. I don't know if he makes that appointment or not, but I'll tell you, that is, for my purposes, a condition of his, well, that is on his PR bond conditions. But I'll also consider it as part of his reporting on the probation cases. So let's see, I'm not letting go of those motions to adjudicate yet. Okay, those are staying pending. So yeah, 1,000 cash surety, 9,000 PR on the 2 new cases, and then just release to streets on the other 2.
Thank you, Your Honor. We appreciate it.
The reporting on the PR bonds is going to be once a month to PR bond, curfew, maintain all mental health treatment, meds, not come within 200 yards of the complainant's residence, so you have no contact whatsoever with any of the complainants, possess no firearms or ammunition, may not leave El Paso County, may not change his place of residence, maintain current contact info, curfew from 10 p.m. to 6 a.m. unless he is working and has provided proof of his employment hours, his schedule, no illegal drug or alcohol, and subject to testing on the PR bond requirements. Let me think. That's it. And commit no new offenses. All right. Anything else?
Nothing from the defense, Your Honor. Thank you.
Thank you very much. Okay, I think we have a few more. Who's next?
I'm a judge, I believe that's it. I'm saying, I missed.
So Mr. Macias had a client to see. I haven't seen him today.
And I left a message several times on his answering machine, man. He didn't answer.
And Mr. Arnold?
I'm hearing Mr. Arnold as well, Your Honor.
Mr. Driscoll.
Okay, well, let's get the defendant. Mr. Arnold, please. Myrna, did we hear anything from Frank Macias?
No, ma'am.
Your Honor, he did contact me, I believe around lunchtime, and I conveyed to him that I did send the plea paperwork. It was sent to him since May, and I did let him know there is a bond hearing today.
We're gonna call it after we finish with Mr. Arnold. Go ahead.
Are you on? No, they told me to come back.
And next, we have Arnold, Cyrus, Arnold.
Do we have, did Mr. Macias acknowledge the Zoom invite, and did he receive the notice of the hearing?
Yes, they did receive it, Judge.
All right, let's take care of Mr. Arnold, then we'll come back to Mr. Armendaris.
In cause number 2022-0D01419 and 2022-0D01421, State of Texas versus Cyrus Jamal Arnold. Announcement of counsel, please.
Well, I came for the state of Texas.
George Driscoll for the public defender for Mr. Arnold.
Hey, and we're scheduled for a bond hearing. Mr. Arnold is appearing remotely from the jail annex. Mr. Driscoll, you may proceed.
Thank you, Your Honor. May it please the court.
Yes, sir.
Mr. Arnold was on PR, Your Honor, and then it has a new allegation pending. He did have some problems with reporting with Alejandro Garcia, I believe was his officer at the time. He is residing he is a U.S. citizen. He's 36 years old. He was born and has lived in El Paso his entire life. He is currently residing at, or would reside at, the OC, the Opportunity Center, if released at this point. He has transient living situation. And he cannot live with his family. Unfortunately, the OC and rapid rehousing are the only available options for him at this time, but he does have potential employment opportunities He does have a job through Glenn Androsco, painting curbs, as well as a detailing service. He is a single male, but has an 11-year-old daughter. He has a GED and is currently has several MH concerns, both depression, bipolar, and anxiety disorder. He is receiving medication for those in custody and is improving. He also does have other health concerns in the form of diabetes. Our office has treatment options available for him if released through EHN, through OSAR, and Tukumi. He has options set up through Punto de Partida, as well as the Restorative Justice Program through EHN. It appears that Mr. Arnold was having some trouble in this most recent situation for being thrown out of a Walmart. That current case is a P file, a 2022 P file 02476, and is scheduled for an examining trial on the 30th of this month. And I believe the theft allegation is, I believe, factually more akin to an unauthorized use of a motor vehicle, but that's a discussion we'll have to have with the state. I don't believe that Mr. Arnold is a flight risk. He is a longtime resident of El Paso, has significant ties with the community, and through the services that we have available for him for housing and mental health services, we believe that he will be able to comply with bond conditions if so released. And we'd ask the court to release him on a personal bond.
All right, Ms. King.
Your Honor, the state respectfully opposes the bond reduction due to the extensive criminal history. Also, I believe from the 168, he did plead true on March 4th for 60 days confinement for theft of property between $2,500 and $30,000. And the date of offense on this case, the evading and the possession is April 14. He actually did pick up April 6, a criminal mischief misdemeanor. There is a P file for resisting that was dismissed. However, there is a pending P file for evading. Date of offense is March 24th, 2022, which is also, there's the P file for the assault peace officer. I see the one that defense counsel pointed out to. Your Honor, I have not put a recommendation on portal due to waiting on the lapse for the possession case. And briefly on the criminal history, it's reoccurring charges of theft of property with previous convictions. We have possession, forgery, evading, robbery, criminal trespass, aggravated assault with deadly weapon. I can go on, Your Honor. Therefore, the state respectfully opposes the bond reduction.
Anything else, Mr. Driscoll?
Just briefly, Your Honor. Mr. Arnold has had some problems with MH, and those have, we believe, caused this most recent incident with the assault on a public servant. The MH concerns, we believe, are running consistently through these cases. And then if he were able to avail himself of the EHN OSAR, both the substance abuse aspects as well as the appropriate counseling for bipolar and depression and continued medication, we believe that that Mr. Arnold will be a successful on bond and successful at reporting to both his court dates and any other requirements for the court.
Okay, thank you very much, Mr. Driscoll. Those requests are denied at this time. Thank you. And so I'll go ahead. Thank you, Mr. Arnold. I'll go ahead and call the next case, calling cause number 2021-0D02888, State of Texas versus Roberto Armendaris. I understand, Mr. Hernandez, what contacts have we had from defense counsel regarding this hearing?
I haven't had any contact, Judge. The only thing I can tell you is the court setting was filed since June 14th.
Okay, so court setting was sent to the attorney. Do we have confirmation, Ms. Melendez, that council acknowledged or received the notification of the hearing?
I'll go ahead and look, Judge.
And Mr. Marufo, the Zoom invite for today's hearing, was that also received, opened by council?
Yes, Judge, I sent it out Friday, the 24th of June, with a receipt that he had received it and they had read it.
And did you receive any communications from defense counsel?
No, Judge.
And what attempts have you made to contact him?
I placed a call at 4:25 to his office and no answer. Again, at 4:45, approximately 4:45, I attempted again and no answer, Judge.
Ms. King?
And Your Honor, just for the record, Mr. Macias' office did contact me, and I spoke to Mr. Macias, I believe, around 1 o'clock today. He was inquiring the plea paperwork for his client. I did indicate to him that I have sent it to him back, I believe, May 1st. And I did let him know that there is a bond hearing scheduled today at 3 p.m. In the for his client. And that was the conversation.
Okay,
And Judge,
so, yes, ma'am.
I do show here that he was served, but it was not opened.
Okay, the notice of hearing was not. All right, so on this one, Mr. Armendaris has popped up here on the screen. However, your attorney is not here. We were scheduled for a bond hearing. So what I'm going to do is set this for, I believe we have in-person proceedings on Friday. So we're gonna set him at 11 o'clock for his bond hearing. Mr. Armendaris will need to be transported from the jail, and we need to get in touch with Mr. Macias and find out why he did not appear today.
I have a hard time getting a hold of it myself.
Mr. Armendaris, please don't speak. You don't have your attorney here. I know it might seem like nothing, but we don't have your attorney here. So we're gonna bring him over on Friday. And we need to make sure and send notice to Mr. Macias.
I'll send that over.
I know he was in trial for a while. Does anyone know, is he in trial? No.
To my knowledge, he's not in trial, but.
When you send the notice, Myrna, we don't have to do it today, but let's follow up with his office tomorrow to confirm and find out if something's going on. All right. Thank you very much. With that, I think, is there anything else, Mr. Marufo?